appeal. So anyway, with In Re Mary Jane R, again, not published, but read it because I do think it's an interesting discussion of the domestic violence, which, we rely very heavily on Daisy H, and Daisy H was mentioned in the In Re Mary Jane R. They also talked about Rebecca C. and David M. and Destiny S. and also Isabella F. With the domestic violence allegation, it was a one-time incident, and there was no evidence that the children were present at all. All of the evidence suggested that the children were with the grandparents at the time of the attack. And again, how did the kids look? They were clean, they were well groomed, they were bonded, they were well taken care of kids. And then with regard to the alcohol count against the mother, they were using the father's statement that the mom had had a drink, and that was it. And so the court goes through and talks about how the police report doesn't mention anything about the mom being under the influence, of there being any mention of intoxication. Neither the parents nor the paternal grandmother had ever seen evidence of drug or alcohol abuse. The appellate court did note that the mom had one arrest for possession of a controlled substance, but they said that was insufficient to prove she was a substance abuser. So I think it's important just to look at the entire case. You want to be looking at criminal history of parents, DCFS history, because you know that the department's looking at all that history and they use it against them when there is something, and then oftentimes there isn't. They'll say there were no hits. And so that is important to note. I also like talking about In Re Jan a lot for the one-time incident. And with the domestic violence case with In Re Mary Jane R, they did find that there was no evidence the violence between mother and father was ongoing or likely to continue. So my biggest takeaway from Mary Jane R is just definitely talk to the other attorneys on the case, because this mom is really struggling right now with department's intervention in her life, and the department is just trying to find something to refile on. So hopefully, as of right now, she still has her children, so that's great. And I'm also wanted to note that with appeals, I hadn't really had too much interaction with the appellate attorneys for a long time. And then once I started in my current courtroom, I think maybe because I've been filing more appeals than I have in the past, I've been contacted by them a lot. And so I was sort of assuming that any time the appeal was going forward, I would be hearing from appellate counsel. And that's not the case. So it's something to consider. For example, I had a case where we were appealing the jurisdiction, the dispo was home of parent mother, and the case closed. Now, I had always known to put on the record, even if the case closes, we are not waiving any appealable issues. But I was lucky that on the day the hearing was on the day the 364, the recommendation was to terminate, Melissa was covering for me that day. And she had the mother sign a notice of appeal. So I called the appellate attorney when I got back, and the appellate attorney said, yes, definitely file that notice of appeal just saying we object to the orders and the findings of this specific date when jurisdiction was terminated, and that would preserve the appeal. So now that's what I do. I talked to another appellate counsel on a similar situation. She said, yes, definitely have your client sign the appeal. And the thing to consider is, because for a while people, we were being told, well, try to keep the case open. We want to keep the case open, but our clients don't want the case open. So at least with filing the appeal, it's a way to say, okay, look, this is still an issue and we're not waiving anything.
Because otherwise the Court of Appeal may determine that the appeal is moot, because there's no effective relief that the Court of Appeal can grant because the kid's home and the case is closed. But the whole issue that you're appealing is that it shouldn't have been here in the first place. So you don't want to waive that initial juris dispo finding.
What would you recommend saying on the record at that 364 hearing before you file the appeal?
What I say is, we agree. I don't say the word submit. I say I agree to terminate jurisdiction. My client is not waiving any appealable issues, and then I have her sign the appeal, and I file it that day. Javon, did you have a question?
This is my question.
Okay. Additionally, I also had a situation recently where I was appealing a no reunification at disposition. And do you know why it was an appeal and it was not a writ? The 2-6 was not set. The other parent got reunification. So I had to go online. I went up to, I searched online for the status of the case. I found who was representing our client, found her number, called her. She hadn't even started working on it, but she had the case. I reminded her who she had and who she represented. I talked to her about the facts of the case and why I was really passionate about it. And I think that, and now this woman's calling me like every week. She's really nice. And I think that my interest in the case moved up her priority. It's just like when we are getting phone calls from a really passionate public defender, we're going to be giving that client's case probably a second look. So, and how many clients file appeals where we end up getting those Phoenix H responses? So a lot of times, you know, CAP is, I'm sure, just as overwhelmed as we are, and it's helpful when you feel really strongly about an appeal. If you're not hearing from that appellate counsel, I think it's helpful to call that person to say, this is a righteous appeal in my opinion. These are the issues that I saw at the trial level. And so in this particular case, this woman, like I said, is now calling me. She's asking me questions. She's almost looking at me as co-counsel in some ways. I mean, asking me about different things that she feels I think were mistakes. And I'm hopeful that we're going to prevail at the appellate level. We'll see. But at least we know that the appellate attorney is taking this case seriously and is giving it a second look and isn't going to just kind of pass it over.
And another thing is, if you have a case where there are multiple appeals, because sometimes we have clients where, you know, they'll appeal every hearing. Some of those cases, you know, are problems and they really don't have a lot of meat to them. But sometimes the court just continues to make erroneous orders, and you have one problem, then it's compounded by another. So in those cases, I think it's really helpful to speak to appellate counsel, keep them updated, because they do need to know what's going on, and to try to brainstorm on what you can do to make the next argument, to preserve the record for the next appeal, and kind of work collaboratively together with them so that you're making the record that increases the odds that they'll get a reversal. So, and it's important to keep them posted, because if something does happen that does moot out the appeal, it's in good faith to notify them so they're not working not knowing that this is all going to be for naught anyway, and they'll appreciate that. So I think, for those cases where you have issues on appeal, it's important to just stay in touch with the appellate attorney, I think.
Yes. And you also build good faith between yourself and the appellate attorneys. I mean, I'm seeing a lot of similar names, and I work with some of the same people, and so they know how seriously I take my cases and the records that I make, and you want the appellate attorneys to know you and to know that you are a passionate fighter for your clients as well. Were there any questions at this point? The only other thing I wanted to mention was that I've also started appealing. I appeal things sometimes that aren't just at the disposition, or just if I'm appealing on just like a denial of a 388. So, for example, I had a case recently that we won on appeal where the client is a truck driver. He'd been ordered to drug test in his case plan, and he'd submitted to more drug tests than were actually ordered, but he'd had a few missed ones. So of course the department said, well, he has to do a full drug program. And I just felt that was going to be the kiss of death for our client because he was on the road all the time. So I argued that at the contested 2-1E that he should not have to do this component of the program. Did not prevail. The court ordered the program, and I appealed it. It was an appealable order. I think sometimes we forget that we can appeal any order, really. And so I appealed that. He still got his reunification. He got 6 more months. At the, for some reason that seemed to move a little bit faster than other appeals I have. When we came back at the next review hearing, the recommendation was home of parents, but the Court of Appeal still found that he was not ordered to do a full drug program. And that was important because if the case comes back, you know that's going to be brought up, that he didn't do the drug program, and now it's off of, now it's found that he should not have been ordered to do it. So it's just things like that to be thinking about. Obviously reasonable efforts, which I know we've had a training on, you know, the other things to consider for appeals. So that's about it. Okay.
I had a case recently where, talking about appeals, I filed an appeal on a kid that got sent out of state. I had the losing parent. And the appellate attorney did not contact me right away and kind of tried to put the blame on me for not refiling a second appeal when the, so what happened was that the kid got sent home with parent out of state. We filed the appeal on that issue. And the court issued a stay. In my mind, when the stay was lifted, because I had made a record on the day it was lifted, I had just stated on the record to incorporate entire argument as to why we were not in agreement, and I felt that that was enough. But the appellate counsel suggested that I should file an appeal again to preserve it. So I don't know if I agree with the appellate counsel or not, but just to be safe, he wasn't sure either if the appeal was moved or not at that point. I felt like it hadn't been moved, but we'll see. But just in case, if you hear that.
Sounds like you preserved the record.
It's on the record, so.
Yeah. It sounds like you preserved the record enough.
I feel that way, but just in case.
Okay.
Right.
Yeah, so if you have doubt, you know, I mean, there are the 60 days for the notices of appeal, so you do have time
Right.
to consult with an appellate attorney or ask your writ
In this
attorney.
case, the appellate attorney did not call me until after the 60 days, so I couldn't run in
Oh.
and file.
Oh, well.
Yeah. Just document the file. Okay. Thank you all. Oh man, I thought we were going to get away with no Marlene questions.
I want to reiterate something that Emily said that I think is really, really key to all of the attorneys, but especially to the new attorneys, because there's not a day, or maybe every other day in my office, that an attorney will come in fuming, crying, putting their iPhone down and saying, I'm about to quit because I made this really good argument. And this one especially for many years has come into my office with that kind of frustration. And please, new attorneys, remember, for every one of these fabulous published opinions that have made law in the state of California, in which dependency attorneys all over the state use, and for the unpublished opinions that give you the theory to argue, even though you can't cite it, there was a trial counsel in your shoes that the court didn't listen to. But the appellate court listened to you. So don't be afraid, make your records, take your appeals, and then the really cool thing was when Rebecca C. got published, I got to give it to Emily and say, show this to your mom and dad, okay? That here's your published opinion, okay? So go out there and get your published opinions, all of you.
And certain divisions are becoming much more open to real life situations in LA County, so we're getting better and better results than we did 20 years ago. So don't get discouraged. All right.
Thank you. I do. I feel great. I still say no one's as excited about that. It's like for cat talk. Yeah, of course.
Very good.
Yes. So what I did was he had 11 tests that he actually went to. So I just said, Your Honor, I'm counting one. I did that. I just was like, I'm counting 1, 2, 3, 4, 5, 6, you know, whatever amount it was. Every single one was negative. And he's a truck driver. And that's documented. And I did stipulated testimony that he tested for his job as a truck driver. And his job requires him to remain clean and sober. And he didn't care. And we appealed it. Yes. That any misdemeanor program, that's why anytime it's ordered, I just say to my clients, you can't miss because they always miss. And then they have to do a full program. And
Notwithstanding that, you were able to.
I was because if you want to give me your email address, I can email you the unpublished opinion to you. Okay, great. Awesome.
Really good.
Great. Nice to meet you. I don't know if I met you.
John.
John, nice to meet you.
Thank you.
It was the same issue.
Yeah.
No, you're fine. It wasn't. Do you know the name of the street?
I'll look it up. Oh, actually, I'll look it up today because I have it on calendar.
That's so weird.
Some of them are
I was
grumpy.
like,
No, if it was a
sounded to
different.
me like he didn't want to do it anymore.
Well, yeah, I mean,
Like,
if it's a different issue altogether,
it's not.
fine.
It's the
But
same
it's
thing.
no, and it just was like a revisit on the stay.
Yeah, and then he's like, what happened? I said, well, it's closed. The stay was lifted. Did you file another appeal? I was like, I didn't think I had to. Like, it didn't cross my mind.
Whatever.
Because,
Don't even worry about it.
I wouldn't know.
No, don't. That is not one to worry
I
about.
mean, like, my clients are losing stuff.
Yeah,
But-
why? I know. No, you're a good advocate. Oh, by the way, I got a
Yeah, Landix.
Yeah.
Which one?
Is she overseas?
Yeah.
Okay. Because of course Charles.
No, it's just like she's been very, oh, thank you.
But I don't think my file is documented enough. And I just get a statement. But
I don't think there's.
I had a problem